My name's David Savage. I covered the Supreme Court for the Los Angeles Times. And one of the really interesting issues in the year ahead is the Second Amendment and the right to bear arms. Not a new subject, but the court recognized gun rights in 2008, first time struck down a law and said, you have a law-abiding citizens have a right to have a handgun at home. They later said last year, you have a right to a state permit to carry a concealed permit. But both of those decisions, a lot of the language was, we're going to allow regulations and the Second Amendment is not unlimited. But Clarence Thomas wrote an opinion in this New York case a year ago that basically said that the Second Amendment was adopted in 1791. And if you California, or any state, want to enforce a gun law, you have to show that it is in keeping with the historic tradition of firearms regulation in 1791. And the truth is there were very little firearms regulation. And there's a whole bunch of modern problems like domestic violence, for example. A lower court recently struck down a law that made it a crime to violate a restraining order in a domestic violence situation, that the restraining order takes away the guns so as, because the woman may be in great danger. And a federal appeals court, citing the Thomas opinion, said that's unconstitutional. It violates the Second Amendment. Why? Because there were no such laws in 1791. And so the reason I've been writing about this is because it's really, if you take that seriously, there's a whole series of gun laws that are in danger. Governor Newsom filed a friend of a court brief in the Supreme Court in April, basically urging the court to take up this case that I referred to, the domestic violence case. It came from Texas, and sort of rein in the law, because he said, California has a lot of gun regulations. For example, there's a ban on assault weapons, large capacity magazines. The state has these red flag laws where you can get a restraining order if a family member or the police says this person is dangerous, we need to temporarily take away his guns. So California is very proud of, and I think understandably so, a series of laws and regulations that are try to limit the danger of guns. But now you have this Supreme Court opinion out there saying, well, you can't have a gun regulation that cannot be justified as part of the American tradition when the Second Amendment was adopted. So I think this is a really big deal, a really big issue to follow in the next 6 months of the year, because the court's going to take one of these cases, the domestic violence case from Texas, and sort of sound off. And the justices are basically need to explain, do they really mean what Thomas seemed to say? No gun regulations at all, unless they're consistent with 1791. Or are they going to say what I think perhaps Amy Barrett and Brett Kavanaugh, the sort of conservatives who may be the deciding people, they've said that certainly the government can limit guns in the hands of dangerous people. Law-abiding citizens have a right to guns, but we're not going to strike down laws and say dangerous people have a right to have a gun. And so that's a big issue in the next year. And the Second Amendment is one of those topics where there's great interest because of the split in the country over gun rights, and just the fact that we've had so much gun violence in this country that a whole lot of people think the problem is too many guns. We don't need more. Governor Newsom has been very interested in this issue. As I say, California is sort of on the front line of having stricter gun laws than most states, and he wants to keep it that way. As you probably know, he's also advocated a new constitutional amendment, the 28th Amendment, to change the Second Amendment. That, I think a lot of people think probably the Second Amendment should be changed, but the truth is it's very hard to change the Constitution, and there's very little prospect that that's going to happen anytime soon.